Good afternoon. It's Tracy B, the divorce solutionist. Yes, I'm the divorce solutionist because I have solutions for every problem you may have: divorce, custody, um, some child support, not every problem, but most of them. Any major family law related issue, problem, dilemma, circumstance, situation, I have a solution for it. I have not met a problem that I didn't have a solution, an answer, a resolution for. And if I did, it was not many. Anyway, I am here today doing Thick of It Thursdays as usual, 4 o'clock p.m. Eastern Standard Time every Thursday here on my channel, on my Facebook page, and in my group. I go live and I talk about topics related to family law. That's right. Specifically divorce, custody, like I said, some child support, uh, occasionally domestic violence or order of protections related to couples, families, but that's pretty much the areas that I really focus on. So today, at the prompting of one of my very good friends and actually a client too, I decided to do a little something different today. I decided to talk about um, popular divorces, divorces in the media. Yes. And the one that I chose for today is Brad Pitt. Now, I think they started their divorce back in 2016 or 17, what, 5, 6 years ago. But I don't know how many of you saw in the media that custody was just decided in their case. They have 5 or 6 kids. Some of them are actually at the age of majority, but I think maybe 3 or 4 of them are still minors. And so they were the topic of they were the issue, uh, the kids that were of issue in the custody portion of the divorce. So recently, and their case is venued in California, although they lived, I don't know where they lived, but they were living outside the country. But I guess for jurisdictional purposes, California had jurisdiction over their marriage and the kids. So not too long ago, and I'm going to be reading because I don't remember all the details, but not too long ago, I think a couple of days ago, I had a news flash. I don't know where I saw it, but I saw it somewhere where it flashed across either my email or my screen and my Facebook, whatever, that Brad got joint custody. And Angelina is not happy about that. And I'm not surprised that he got joint custody. Let me tell you why. First of all, let me back up. The reason she thought that she would get sole custody is because California, like a lot of other states, have in their statute, in their rules, and their laws that when there's a history of domestic violence, domestic abuse, that the courts are not allowed or not permitted to award, rule, order joint custody amongst the parents who are parties to the domestic violence or the domestic abuse. So what I understand is the reason Angelina filed for divorce in the first place is because of an incident that happened on a plane while they were going to or from home. And Brad, who was allegedly inebriated to the point that he not only assaulted her, but he assaulted their firstborn, which I think his name is Maddox. Of course, there's a dispute as to what actually really happened, but that was her grounds for the divorce, and she sought an order of protection based on that. So, what happened in the order of protection portion of the case is that I guess they had a hearing, and Brad was, acquitted. He was, the charges were dismissed. He was found to have not actually done exactly what Angelina said he did. Now, that does not mean he never physically assaulted her or her kids, their kids, but that particular incident, she filed an order of protection and it didn't stick. Nothing substantiated came of it. But she also used that as the means to justify her seeking sole custody. And I hear she's planning on appealing. She's saying the judge was biased, blah, 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 because he still wind up giving Brad joint custody. And this is the thing, and this is what I noticed with talking to a lot of people in my audience, is that and every time I see this question come up, or a question related to domestic violence and custody or even divorce, I am, excuse my nails, I need to get my nails done. I am trying to get people to understand that allegations of domestic abuse, and I'm not, when no one's in everybody's home to see what actually really happened, but allegations of domestic abuse is not enough to justify not being awarded joint custody, or you being granted sole custody if you're the one using that allegation to seek sole custody. Allegations is not enough. There usually has to be a trial or hearing, and there has to be a finding. The judge has to find that there was, in fact, some abuse that occurred. I don't know how fair that is, because a lot of times it's hard to prove. It's one person's word against the other. There's all kinds of, and I do understand the cycle of abuse. So I understand a lot of times people don't report it. They don't go to the doctor. They don't go to the hospital. They don't, take pictures. They don't have witnesses. They don't have all of that. And if they do, when it comes time to having a hearing or a trial on the issue, for some reason, it's just not, it doesn't meet the standard of proof that's required for the judge to enter a finding that there was, in fact, abuse. And so her allegations, again, I wasn't on the plane. I don't know what happened. Obviously the judge didn't believe that, Brad actually committed any sort of offense that arose to the level of domestic abuse, right? So now she's upset. She wants to appeal, and she's saying that the judge was biased. What she also mentions is that their youngest, I think, is like 13 or 14. And she was pushing to have them testify or do an in-camera with the judge on the custody portion of the case. And the judge refused. The judge refused to speak with the kids, or to even allow them to speak openly in court. And she's saying that that was an error. So that's one of the bases for her appeal as well. And that's another thing. That's a whole nother issue, but I'm going to talk about that too. So we know each state has a certain level, a certain age where they will allow kids to have a say in who they want to live with, right? How they do that, though, that differs. Some states will allow in cameras, which is an in camera. In camera is when the judge and the child's lawyer are present, and the judge gets to ask the child, questions. That's it. No one else is around. That's it. Sometimes sometimes they do it on the record. On the record, meaning a court reporter present. I'm not sure. I'm sure some states do that. Not all. And then some states allow kids to have a say in their preference by speaking through their lawyer, which is their guardian ad litem, their law guardian. There's another term someone mentioned to me the other day that I've never heard of, but whatever it's called in the state you live in, it's the lawyer for the child or the kids. They may speak with their clients, get the client's perspective or preference, and relay that to the court. Or some, not many at all, some will allow the kids to actually testify in the custody trial itself. Not many judges do that because they think it's, traumatic, it's emotionally taxing, burdensome for them to, speak openly and, maybe, sort of get one of the, upset one of the parents over the other by speaking openly in court, telling the court who they prefer to live with. But in most cases wherever the option is, in most cases, the judge will use their discretion. There's no mandatory, well, some states statutes say the kid at 13 shall have a preference. But what I'm trying to explain is that even when they do, the judge still has to look at all the other factors. So say in your state, there's 10 factors that goes into deciding who should get the kids, the best interest standard. Say the best interest standard in your state is 11, 12 factors. And one of those factors is your 13-year-old's preference about where they want to live. Yeah, but there's still 11 or 10 other factors the judge is going to take into consideration. So that's what I mean. So it's not that it's most likely not determinative of just because a child says she wants to live with dad or mom, that's where they're going to wind up living. It'll be factored in with all the other factors. It'll be weighed in and taken into consideration with all the other factors. But that's where it ends. That's just about it. Okay, it doesn't. A 13-year-old doesn't come into the courtroom or to the judge and dictates where they want to live. Sometimes, but for the most part, no. So Angelina is really, pissed. And she's, she's determined. I hear she's determined to appeal this case and have this judge's order overturned. Okay. First of all, why are they going to trial? I'm looking at it now. Their divorce was filed in 2016. They're just having a custody trial in 2021. I mean, okay, let's not even count 2020 because we know 2020 was a wash. But that's 17, 18, 19, 21. That's 4 years. I mean, they're actors. I mean, I don't know. Have you guys seen them in any movies? Because I sure haven't. So what are they doing? Why are they so busy? Why did this case, the custody portion of this case, even the divorce itself, why is it dragging on so long? Usually with entertainers, it's usually because, the conflict in scheduling, pretty much that's it. They're scheduling and, the logistics and all that stuff. But 4 years, and that's just the custody portion of it. But anyway, I digress. So yeah, another thing is, in some states, let me just back up. Most states have a presumption that joint custody is in the best interest of the child or the children. Most states. And when I say presumption, what that means is that they may not have. So again, let's use your state that has the 11 factors. The presumption of joint custody being in the best interest of the child may not be a delineated factor. It may not be a factor that's actually spelled out. But that's a notion. That's a policy. That's a frame of thought. That's a philosophy. That's a perspective that most judges have, most courts have, most state legislatures have, that having both parents, having joint access, joint visits with the kids is in the best interest of the kids. So that's a starting point. That's usually a starting point for, and it's and they're in California again. They're in the jurisdiction of California courts. They're no different. That's a starting point. So what happens is they start at that point. They start here, and then either they go either this way or that way, depending on what the other factors are. The judge starts, considering all the other factors one by one, and it either takes them up or down in a direction of joint custody or not. And because there is a presumption that joint custody is in the best interest of the child, they're always going to look at the other factors with that frame of mind. They're going to look at those factors with the thought in the back of their mind that it's best that the parents get joint custody. What happens though is, again, with domestic violence, or in some states, it's enough to say that the parties just don't get along. They don't communicate, they don't get along, and automatically joint custody is taken off the table. Okay. Apparently, California isn't one of those. Or it could be that they're, Angelina Jolie and Brad Pitt. So, let's keep it real. We know that the rules and the laws apply differently to entertainers than, just regular folks like us. That could be it too. I don't know. I didn't follow the whole trial or the whole debacle because I actually really thought they were already divorced. I thought their case was already done. I wanted to talk about Kim and Kanye's divorce because that's pretty still new, which I might do next time. But I chose this one because of the email that I got that said, "Oh, Brad Pitt wins joint custody and Angelina is upset." Or something like it said something like that. I know it expressed that she wasn't happy, and and what that mean? What does that mean? What does that mean now that he has joint custody? Well, I don't know because I don't have the order in front of me. But what I'm assuming is that they're gonna have to split time with both parents. And joint custody doesn't always mean that. It doesn't always mean that they get equal time. That's 50-50 custody. But it depends on how your court uses language. So joint custody can mean just joint legal custody. And the time is split 20-80 or 30-70 or 40-60, you know? And sometimes it does mean 50-50. We just don't know. We don't know because I don't have a copy of the order. So what does that mean for her? She didn't get sole custody. That means she's not the sole decision maker. She doesn't get to determine if they leave the country. She doesn't get to determine, where they go to school. She doesn't get to determine, any sort of medical treatment she wants for them to have or not have. She doesn't get to make those decisions on her own. Now, she might still have more physical custody, but the fact that he has joint custody, yeah, they have to make decisions jointly. They have to make decisions together. And that may be a disaster too, given the fact that she's made these allegations of him. She says he's a pothead and an alcoholic and he's abusive. That's what her allegations were. Apparently the pothead and the him being an alcoholic never really I don't want to say it was never really considered, but it never really it didn't outweigh all the other things that supported him getting joint custody, obviously, because he got it. So why is she pissed? She's probably pissed because she wanted to be the one to have the final say. She wanted to be the one to make those decisions for her kids. Now, for me, as a lay person, having sole custody, you know, I wouldn't think that she would get that in the first place. I don't know. Only because he's always been a hands-on dad. From the moment they, decided to start having more and more kids, adopting them, having them, whatever, he was always hands-on. Well, from what I see, I don't know because I wasn't in the house. Again, it's like I wasn't in the plane, I wasn't in the house, so I don't know. But I'm assuming, from the pictures and the reports and everything, and I think from what I read, she actually admitted that he was very hands-on. So he was very hands-on. Now you want to exclude him? Now you want to, limit his access or his input? Personally, I don't think that that's the cool thing to do. Professionally, I I get it. Excuse me, I get it. I do understand why people ask for that. But personally, I'm just an advocate of, if he's always been hands-on, he should continue to be hands-on. You should allow it because it's not just about you and it's not about him. It's about the kids. If they're used to dad, coming to pick them up from soccer practice and taking them to dinner, if they're used to dad being the one to take them to the dentist, or they're used to dad being the one to stay at home with them when they're sick or whatever, why should that stop? Of course, the logistics change, because, if there's two homes now as opposed to one, that makes things a little different. But why should that stop? Just because, we're not a traditional family anymore? Kids, I think kids thrive, better. I think that's how you minimize their emotional turmoil they endure as a result of the family breaking up, is that you try to maintain as much consistency and continuity and persistence as possible. And that means if dad needs to, be able to still come and pick them up or attend, sporting events, blah, 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 that you figure out a way. I mean, of course, if there's really abuse, then that's different. If you're suffering from PTSD or any sort of trauma as a result of a real abuse, and again, I'm not saying either way whether there was abuse in their relationship or not. I'm saying if there is abuse and you don't want him around for that reason, I understand. It may not happen that way because some courts will still say sorry, right, wrong, or indifferent. They will still say sorry, he's dad or she's mom, and they still should be involved. You don't have to be there. You can put parameters in place so that you can minimize contact with him or her. You don't have to be there. But why should the kids suffer? If the kids don't are not expressing any sort of trauma as a result of domestic abuse, then why should they suffer? Why should their relationship or their bond suffer? Right? So again, right, wrong, or indifferent, I'm not here to dispute your position. I'm telling you mine. And I'm trying to give you some insight from my perspective, personally and professionally. So anyway, I think that what I wasn't sure of is I saw some places that order was temporary, which I don't understand. I don't know if they meant temporary because she put the court on notice that she plans to appeal, or that it was temporary while the divorce is still pending. But it clearly said, everywhere I read, it clearly said that there was a hearing or / trial. And usually a hearing / trial, those orders are not temporary. Those are final orders, unless I don't know. So I'll delve into that a little bit more to find out, but I don't know. But anyway, it's hot over here. So let me just read this quote. A source allegedly close to Jolie said that, and I quote, joint custody is not the issue that Angelina objects to. There were other issues of concern. But of course, the court proceedings are closed and sealed. My guess is she's concerned about the drinking and the smoking, weed. And that I guess when he does that, he gets a little antagonistic or obnoxious or maybe even violent. If she really has, and this is the thing too, this is another thing, because people will say, what I noticed is people will say, oh, now they're concerned for their kids' safety. And I'm not minimizing domestic abuse. It happens. People die every single second of every single minute of every single day from domestic abuse. However, I am not lost on the fact that people take advantage of the order of protections and the restraining orders and how they're used in family law and family court cases, especially custody cases. And I am not an advocate of that. I am not an advocate of someone running to court to get an order to allege domestic abuse from a situation that happened 4 or 5 years prior that only resulted in a screaming match that they started. I'm not a fan of that. I am not, and I never will be, because there are people who are really being hurt and abused and traumatized, and they are the ones who really deserve the assistance and the support of the court personnel of the family law arena to help them get the attention, the assistance that they need. But because of the former, a lot of the latter don't. So the courts a lot err on the side of caution, and even when there are real allegations of abuse, they that doesn't stop them from allowing parents to see their kids. And I get it. Another point is that they do it because a lot of times the kids are not, they won't admit, they won't disclose, they won't express that they're afraid of or they're concerned about any domestic abuse. Sometimes they're not even aware that it even existed. Not that it didn't, they just don't know. Or they do, but they've never been a target of any abuse. And they still love both parents and they still want to be with both parents. And I mean, there's a lot of scenarios, but the reality is, should the kids be deprived and should the parents be deprived of the kids when the kids are not really in danger? So now either parent is alleging that they're concerned about their kids' safety and welfare because of, whatever it is they endured, but the kids have never been subjected to any sort of harm or danger. Not to say that it won't happen. I'm not saying that. It's a tough question. It's a very tough position to be put in. It's a very, I mean, and I'm talking about the parties, the litigants, the kids, the social workers, the therapists, the judge, the lawyers, the guardian ad litem, everybody. It's a tough predicament to be in, to make that decision, to make that call. Because, we've seen in the last year or so where, a couple of cases I know where dad got, the child was never a target of abuse, but dad got the kid and killed himself and the kid. I've seen that happen like 2 or 3 times in the last couple of years. So it's a tough call, but it's something to think about. The people think it's cut and dry. It's not always cut and dry. And, family law judges have like a few minutes to make a decision that can change everybody's entire life, can turn their world upside down. I would never want to sit on the bench and be in that position, because I don't know how they sleep at night. I don't know how they are able to sleep at night. As a lawyer, when I did practice, I mean, I had my moments. I had my moments, when I would come home and be like, wow, did I make the right call? Especially as a guardian ad litem. Oh my God, did I do the right thing? Or, I remember some cases vividly. But you do it, you do what you can, you do the best you can. But anyway, again, I digress. So that is my take on Angelina and Brad. I hope that he gets help if he is an alcoholic and he's, has some sort of anger issues, problems, that this will prompt him to get the help that he could benefit from and his kids could benefit from. And that, him and Angelina are able to co-parent and, do it with, with love, so that the kids don't suffer anymore. And, that's all I have on that. Anyway, I am going to, let me just tell you. So I am working on officially launching my YouTube channel, where I will be doing some tea stuff, and just a myriad of things, just a myriad of, things that I think is important to my audience. So look for that, please. Also, I am adding some stuff. I told you this the last few weeks that I'm adding some stuff. I'm still working on adding some stuff, adding the workshop, adding some ebooks, adding some other things that would definitely help you no matter which stage you're in, which phase you're in your divorce, your custody battle, whatever. No matter if you're represented or not. What I have is gonna, it's gonna be helpful to you in some shape or form. Something I have will help you, because I'm dedicated, I'm devoted to doing just that. But anyway, you can follow me on Facebook at the Divorce Coach. No, it's the Divorce Solutionist on Facebook. It's the Divorce Solutionist on Instagram. It's the Divorce Solutionist on LinkedIn. Is the Divorce Solutionist on YouTube. I have groups. I have Pro Se Divorce and Custody on Facebook, and I have the Divorce Glow Up. And I have 2 different groups, because the Divorce Glow Up is the first group I started, and it was geared toward more represented clients. I mean, there's some pro se clients in there too, but it was more geared toward helping represented clients navigate their way through dealing with the lawyer, dealing with the court system, finding ways to deal with the emotional stress, the financial burden, all that stuff. And then I started Pro Se Divorce and Custody, because I noticed that there's a lot of pro se litigants out there and they could use some guidance. And I wanted to, provide a different set of resources just for them, because their needs are a little different. So look for them. If that is you, in either that, if you're going through a divorce or custody, or considering it, or you're post-divorce or custody, and you may be going back to court, or your ex may be taking you back to court, join either one of those groups, because I go in there and I try to be as active as I can. It's kind of hard sometimes when I'm doing a bunch of other stuff, but look for that to improve and to get better. And I'm always working on improving and adding and upgrading and all that stuff. So, but feel free to let me know what you think. Tell me what you'd like to see, you'd like to hear, um, what's not working. Tell me how things are going for you. Tell me if something I've said to you resonated with you or if it's helped you. I'm a strategist. I am a strategist. I am not a, I mean, I practiced law. I was a guardian ad litem. I do some mediations, but I'm a strategist first. That's my thing. Strategy is my thing. And what that means is you got a problem. I'm going to figure out a way to solve it. We're going to work together. You're going to give me what you got. I'm going to give you what I have. We're going to come up with a strategy that's going to get you some results that you want, that you expect, that you deserve. That's what I do. That's who I am. Tracy B, the divorce solutionist. Until next week, take care.